Good morning, ladies and gentlemen. This is the February 9, 2022 meeting of the Board of Adjustment of the Municipality of Anchorage. I'm Bernd Gutschow, its chair. Madam Clerk, would you please call the roll?
Yes, Mr. Chair. Mr. Gutschow.
Yes, here.
Mr. Diak.
Here.
Ms. Peace.
Here.
Mr. Stewart.
Here.
You have a quorum.
Thank you so much. I also should mention that there's with us the clerk, Barbara Jones, and our trustee recording secretary, the clerk, Jennifer Beneclassen. And, of course, Dennis Wheeler, our esteemed counsel. The first item on the agenda this morning is to approve the agenda. I don't know if you have seen it. Things were coming over the internet hot and heavy the last couple of days, so if you have not had a chance to look at it, please do so now. And if you are all done with that, I will simply entertain a motion to approve the agenda.
Move to approve.
Has been moved by Mr. Deek and seconded by Mr. Stewart. Any discussion? Seeing none, the minutes are approved. Next item, we need to go to the minutes of the previous meeting, and that was a very short one, relatively short one, on December 14. I don't know if you've had a chance to look at the draft of those minutes. Present at that meeting were myself, Mr. Deek, and Mr. Stewart.
Yes.
And Ms. Pease was not there. So, any additions, deletions, changes? Mr. Stewart, you're always good at catching small and big mistakes.
I don't see anything.
Oh, that's wonderful. Mr. Deek, anything that you see that needs to be corrected?
No, it looks good for me.
Okay, if not, Mr. Stewart, I gather you are going to make a motion to approve those
Motion to
minutes,
approve.
aren't you?
Second.
And it has been seconded by Mr. Deek. And is there any discussion? Seeing none, those minutes are approved. So the next item is there's no old business. At least I'm not aware of any. Are any of you aware of any old business that we need to attend to? No? Okay, then what brings us here today is the proposed Assembly Ordinance, AO, that has now been passed around numerous times, and it appears, Mr. Wheeler, are we the last ones to comment on this? Because I know you have worked into the version that we have in front of us and that we're going to be working from, comments from the others.
Correct.
Why are you sitting higher than I am?
Because he's comfortable.
Isn't it? Just be proud. Don't worry.
It's this.
Mr. Chair, there is a tab on the
There is?
There is on the
right-hand
right-hand
side.
side. Right forward. So if you push it down and stand up a little bit, it should.
No, I'm...
No,
No.
just stand up.
You
We
have
can-
to
yeah,
stand up
stand up
and
at the
push
same
it
time.
down.
like
There you go.
Oh, Dennis, you are not...
Let me fix this.
Okay, you're on equal status now.
Okay, all right. A little levity is always needed here at these meetings, you know. So, what we are proceeding from is the version that Dennis, Mr. Wheeler sent around at 10:30 p.m. night before last. And hopefully your printer is better than mine, because I was unable to print red line because I don't have a color printer. That's why, I think. Anyway, what I'm proposing to do is, and what I suggested to you in an email, is that we simply go through this paragraph by paragraph. When I first worked from a previous version, I identified 11 paragraphs. I'm not sure that we still have 11, or maybe it's by now more or less. Who knows? But I would suggest that we simply go to page 2.
Mr. Chair,
Mr. D.
can I have a question? I would like to ask one question.
Of course.
Process. So, Mr. Wheeler, you said that you have worked on this, and I understand planning and zoning and planning went through it, right?
Yes, sir.
With their comments, and are those incorporated here?
Yes, sir.
So this is really truly the last stop before all land use boards are looking at it?
Yes, and if I might elaborate, Mr. Chair.
Yes, of course.
So when I started on this, I had a PDF version, and that was the first thing I sent out to you was my comments on that PDF version, which is awkward to work with, as you all
Yeah.
noticed and discovered. In the meantime, I had questions pending through Quincy Hansel, Assistant Municipal Attorney. What did Platting Board do? What did the Planning and Zoning Commission do? What is the intent of some of these sections? Because I felt like if I understood the intent, I could maybe make some further suggestions. So she and I had a conversation about that. Then I got another version of the ordinance from planning, which apparently included the Platting Board and Planning and Zoning Commission edits. So now I had Quincy's input, I had what the Planning Board, or the two boards had done. And I had the concern from the chair, for example, that the PDF is hard to work with. So I thought, well, okay, I need to do something different to help the board. That's why I created this Word version with all of the suggestions and edits, so that would be easier to walk through. The Platting Board and the Planning and Zoning Commission, as I understand it, what they did was basically adopt the recommendations from the Anchorage Home Builders as represented through the Ashford and Mason letter that was included in the materials. So my understanding is they made no other changes. They just adopted those recommendations from the home builders regarding the turnaround time on service and a couple other smaller items. So, yes, this AO now has my comments as well as the edits by the home builders as approved by the two boards.
I have a question.
Mr. Stewart.
Yes, Dennis, is or has this been coordinated with the Assembly Council?
No, I have not worked this with the Assembly Council.
Okay.
Mr. Deek.
Yes, and the next question is following on the whether the planning department has worked with the UDC to do the same thing. Do you know?
Not to my knowledge. I don't know that the UDC is empowered to review this, but in any event, they haven't run it through them.
Okay.
There was no mention of the UDC.
But it governs the proceedings before the UDC as well, and appeals from the UDC, right?
I believe so. If you look
Yes.
at the jurisdiction
Yes,
at the beginning,
yes,
it does.
yes.
So,
Doesn't it?
Yeah,
Okay.
but there was no mention that it had been through the
Yeah.
UDC or that it was going to
Oh,
go
just,
to UDC.
just check in process.
Yeah.
Yes.
Okay.
If it hasn't, that's an error on the planning department side to put it through that commission.
Well, shouldn't they be two?
We had to go back and look at the code and see if they have the code authority to review ordinances. I don't recall. It's been a while since I've looked at it.
I don't know.
I mean, I can look it up online when we have a moment. to
Okay,
do that.
anyway,
Just-
let us, while we're talking about general comments, Mr. Wheeler, maybe you can just give us a brief overview of what these changes, in general terms, without going to specifics,
Sure.
what they are intended to accomplish.
Sure. The AAM describes three major themes. I don't have the AAM in front of me, but unless it's in the packet. But I can tell you that one is to remove new evidence and change circumstances from the code, so that we try to avoid the situation we had in the one particular matter where we had appeals pending, but then yet the lower board heard and approved a motion to consider new evidence or change circumstances, which really tied up the process in unusual ways. So that's been removed. The other thing, and the one that I needed to get clarification from Quincy on, was that we had a process with respect to certain appeals where an individual could file a notice of intent to appeal. That would then trigger the planning department to create a written decision, which would then be approved by the board, which would then trigger the time to appeal. And that's a very confusing and elongated process. So they've removed that requirement to file a written notice of intent to appeal. In exchange, the planning department apparently is going to create a written decision for every case, regardless of whether they know an appeal is coming. So it kind of cleans up that process. So there's a written decision, and then there's 20 days to appeal.
Does that apply to all cases? I know there was an exception of the appeal process carved out for preliminary plats before the planning board. Has that been eliminated as well, so that there's a standard 20-day appeal period for all decisions
Correct.
of the planning of the planning board, P&Z, and UDC?
Correct.
Is that the way it now is intended to work?
Yes, sir.
Okay.
Okay, are we still on the, because I have questions regarding exactly this
Okay,
topic.
let me just
Yeah.
finish. I must tell you, I'm all in favor of providing a longer period for preliminary plats because, as I understand it, at present it is just simply 7 days from the oral decision, and that's a very short period of time. And if you are dealing only with lawyers, that's okay. But I was just recently involved in a case where an individual who has no experience was suddenly faced with a 7-day deadline. And I must tell you, I think that's too short. So I'm all in favor of lengthening that and making it uniform. That's, I think, the real goal here of what they're trying to accomplish. Okay, Mr. Deek.
Yes, so two questions. One is that the repeal of the changed circumstances. Obviously, we run into cases where it caused some procedural issues, but I also know, especially at planning and zoning, that when you close the public hearing and then you table a motion or set an actual deadline to rehear it or go back for decision, and actually in ordinance reviews it happened. There's one in the works right now, which is the R2 ordinance, which was heard. Evidence was presented, and they closed the public hearing, but the new evidence showed up, and they're going to have to redo their hearings because of that evidence. Do you know, and I know it's a specific issue, but do you know how that repeal affects that process, that you basically close the public hearing? What is your vehicle to actually get new evidence if we repealed it from the code?
Correct.
Mr. Wheeler.
Thank you, Mr. Chair. That was one of the questions I had for the municipal attorney's office, and I'm not sure I got the clearest of answers. So here's what I think will happen now that this has been pulled out of the code. You have a situation where, depending on timing, a person could ask the lower board for reconsideration and raise it as a, so a board member would have to
At that meeting.
make a request for, well, it's usually there's a time frame, it's 24 hours, something like that. So it's very short, right?
Sure.
So that's one possible path. The other, and the question I asked was, well, okay, so if there is this allegation of new evidence, how does that person present that, and to who do they present it? As I understand it, there's probably two options. Either A, they raise it on appeal with this body, so it becomes part of their appeal, or B, they have to run to the court on what we would call as an interlocutory appeal and try to get the court to grant some relief. And it's not clear, because the code doesn't address it now, whether you can use both those paths or you have to use the administrative process of raising it with this board first to see where that goes. So
Mr. Chair?
that's
Ms. Pease.
Yes, I share the same concern. So where does that leave a party to a case where there's changed or admitted evidence? If we've taken it out of code and not provided for it elsewhere, it seems we haven't cleaned up the code.
So one of the issues is whether this right exists at all. And by taking out the code, do you eliminate the right, or does it just sit there with an unknown path? What I would suggest this board do, thinking about this, if it wants to do this, it would be to make a recommendation that the municipal attorney's office or assembly council or the assembly
To
answer that
address the
question.
path. Mhm.
What is the path?
Mhm.
If the path is through the administrative process that it needs to be raised with this board before they can go to court, then let's say that so that people know.
Okay.
My view of the matter is, my 5 cents worth, is that it needs to be raised by way of appeal to the court. I'm not sure that there's any logical path regarding the interlocutory appeal to Superior Court. I just don't see that. I think if we approve this the way it is, the only way to raise new evidence or change circumstances is by way of appeal. That's my view of the matter. Now, whether that's good or bad is something we can discuss, but I believe that's the way that the code will be interpreted, assuming we approve this. Any further? Yes, Mr.
I have another
Deek.
question then, procedural. So,
Okay.
So, and I'm like say I'm speaking from I do design, so I'm from developer's mindset. I want to have a clear path of how to get a project done with all the public's ability to review and comment and bring in evidence and all that. So, if you are doing the work, you are getting into a point where the hearing is closed, and again, this is planning and zoning. And then there is some sort of information which comes up, and because of the nature of it, it may come up. Then it is going to have to be appealed to this body based on this current, as we discuss it, to be brought in front of the board again, which means that you're going to have to have a new public hearing at the P&Z level. So now you made the process even longer than it would have been, because the P&Z would act versus getting it to the Board of Adjustment and then back to P&Z. And I wonder what your thoughts on that process is. I don't know if it's clear how I say this, but I could see that that public hearing is closed. They are in deliberation. Maybe they table the case for the next meeting. In that time frame, it perks. Then they would have the chance to perhaps reopen public hearing. I guess they have that chance.
Yes,
The chair does that, have that ability, and then they would act on that. But then it would have to have happened with only the chair and the board working on it somehow to get there, without the public being involved. And that's where I'm wondering how do we even think of that process? Because without the trigger, I don't know how you do it.
So, just to summarize this discussion, there are issues regarding new evidence and changed circumstances that are really not addressed by the version that we have. And Dennis made the suggestion that perhaps we recommend that somebody take a look at this. But I think this is outside the purview of what we are discussing at the present time in terms of the changes that we have. So I would simply suggest that we table this and put it in the form of a recommendation, and say, hey, you need to take another look at this because doesn't seem to be workable. Does that make sense?
Yeah. So how it would do it is put in a recommendation based on what we do in this review.
Yes.
And then put it on the list of items that you, meaning administration, who proposed the ordinance, looks at it and addresses
Hopefully,
this issue.
yes, we'll address it.
And they can have the choice to do it or not.
Yes,
that's where
exactly. Madam Clerk.
I think Ms. Pease was before me.
Oh, I'm
Mr.
so
Chair,
sorry.
yeah,
I apologize.
so-
Ms. Peace. Yes.
I might respectfully raise that it might not be outside the purview of what we're doing here, because if we're taking something, we're trying to simplify and clarify the code.
Yes.
But if we're taking something out of code that then creates confusion, it's kind of collateral. But we're not completing our mission of simplifying and clarifying. So I feel a little anxious about removing a process or a procedure from the code where there still is a need for redress.
Okay.
So that's my take on it.
And I do appreciate that. My only thinking is that we are the last board to take a look at this, and everybody so far has chimed in and said this is okay. And so if we say, no, this is not okay, we still have a concern about this. I think the way to raise this is by way of the recommendation that we discussed. Does that make sense? Because somebody needs to take a look at it. I don't think we are really capable of, without further input from P&Z, for example, that's what Mr. Deek was referring to, of coming up with a clear path and a clear procedure of how to handle new evidence and change circumstances. I'm not sure. So I think it needs to be within the purview of P&Z first to say this is how we would like to handle this. And apparently they've chimed in and said, we are fine with eliminating it. So we're essentially putting the ball back into their court. Mr. Stewart.
I would like to see that intent, once they look at this, and if they do say that they've taken it completely out, what is the intent of their changes on this particular issue? Because
Okay.
if intent is in there, then if it does come up, we know what the municipality was looking at and what they were intending, so we can look at it in a more educated
Yeah.
viewpoint.
Yep, I agree. So, Mr. Wheeler, since you
Yes.
will be the scrivener, just one second, since you will be the scrivener at the end of all of this, would you make a note to
I will.
that
I'll
we
do that.
incorporate this?
Yep. And then, if I might, to Mr. Stewart. Oh, I'm sorry. Go ahead.
Well, I
Ms.
obviously
Jones.
we are great minds think alike, because I was going to offer while you are discussing that I would keep track of these issues for you.
Okay, good.
And I anticipate that the board will probably want to do a resolution, and I can use my notes and then.
My intent is, as we proceed, and as I indicated in my email, that at the end of all our discussions today, that there be a motion done to approve subject to the following. And, our discussion right now should go into the subject to the following column, okay?
Yes, sir.
So that be taken by somebody is being looked at.
Dennis also was going to respond to what I just said. I wanted to hear that if we could.
Yes.
Yes, on the
Dennis?
subject of new evidence and changed circumstances, the AM, which a copy was just passed out, this is drafted by the administration. At the very bottom, on the first page, it talks about this third element of the ordinance addressing this issue. And it says, the current process at line 37 allows any interested party to raise supposed new issues for consideration by the decision-making body in lieu of filing an appeal. In practice, this process is fraught with confusion. So when you turn the page over, the amendments proposed will help streamline the appeal process in front of land use appellate boards by creating a single process available to interested parties.
Oh.
So the opportunity for board and commission members to request reconsideration of any vote will be retained. And of course, if I noted, there is a time period for reconsideration motions. So
Which
then
is-
what do you do after that?
Yeah.
Because it may be that new evidence or changed circumstances doesn't happen within those first few days after.
Well,
the
what
decision.
happens then?
So
Correct.
that's
So-
a partial.
You see,
Yeah, so I think it's appropriate for this board to make a recommendation that there be some consideration as to is the intent then beyond the motion for consideration that an appellant can raise the issue with this board. If so, let's say that in the code
Yep.
somehow, so
Yeah.
it's clear.
okay,
Okay,
Yeah.
great.
all right.
Thank you.
So-
Anything else?
One more thing, so
Yes?
we were talking about what are the general purposes of this
Right.
ordinance. So we talked about this one. You'll see in the AM, the first was addressing that notice of intent to appeal, to eliminate that intermediary step, since the planning department is going to have written decisions available for every case, and then you have your 20 days to appeal. So that it makes it all uniform, streamlined. Then the second purpose in the middle there is to shift tasks from the clerk's office to the planning department, because what has happened in the past is there's this handoff back and forth, and one department may not know where the other one is in the process, and it leads to delay and some confusion. So this tries to shift it. I'm going to be in my draft to you, I'm recommending some further changes, and I know the municipal clerk has some additional changes on top of that, but the idea being that the planning department carries the process of prepping the appeal until it's all ready, right? Fees paid, record ready, transcript ready. Then there's a handoff. Now, the handoff in my original draft would be to the municipal clerk, because that's kind of where it was. But speaking for Barbara Jones here, and she can certainly chime in, but she's going to ask you to consider, let's hand that off to Assembly Counsel, because the Assembly Counsel's office handles legal matters and has a better understanding of all the steps that are involved in that, so that there would be a handoff between the planning department and Assembly Counsel and to this board. And Assembly Counsel, under its current code, has the authority and the power to provide legal advice to you. It could choose to hand that to someone like me outside if it needs to because of workload, but generally speaking, that's the appropriate department to help you work through the appeals.
Question.
So we'll that comes kind of later down in the draft ordinance, but that's the general
So,
concept.
At what point then, and I must tell you, I have not had the time simply to look at Barbara's, Ms. Jones's, the clerk's suggested changes. At what point does it get handed off? What's the intent here?
When the briefing cycle starts, correct?
Correct.
So the clerk wouldn't have to mess with, is the record complete or not? Is the
Mhm.
transcript done?
Planning does that.
Have the costs been paid? All of that stuff gets handled at planning. Because we've had this problem with the record being incomplete,
Right.
back and forth, back
Yeah,
and forth.
yeah,
So
yeah.
planning takes care of it. When that's all done, all that preliminary work, and now you're into the meat and potatoes of what are the arguments, what are they fighting about? That's when you have it.
Mr. Chair, when you're ready with your question, I have a follow-up.
Okay, Mr. Deek.
Oh, are you ready with your?
Go ahead.
Oh.
Go ahead.
So I like the clarity. That's good. That's good. We're doing something good. I have a question though, because what happens is that the funding mechanisms don't track with the workload of various departments. So the planning, working with them, oftentimes I hear, this is what I hear: we're too busy, we're overloaded, we have 15 projects going constantly. And it's like, well, I mean, this is not that complicated. Why is it not working? Because, and then you hear that, oh. So is there a way for us to recommend that the administration then also proposes a path for funding that particular process with a person in the office which may be tasked for this, or maybe partially tasked for this, but very specifically owning this process? That the ownership of the process is very important to me, because if we just say the planning department will do it somehow, I'm concerned that it will get messier than it has been. And I'm sure planners may hear me somewhere today and they hate me for this, but this is the experience, and I want to make sure that it's known.
Okay.
Mr. Chairman, I think
Mr.
it's
Wheeler.
certainly within this board's power to recommend that if the planning department is taking on these additional tasks, that the administration give consideration to appropriate funding to make it happen timely.
You know, that
Yeah.
job to manage it somehow, yeah.
Yeah, absolutely.
Okay. Any further? Yes, Ms. Jones.
Since we're on the topic of cost, I think that it's a great topic. And it has been suggested to me several times that the current cost of an appeal is way, way under what this costs us. And I think the board knows how much time you spent on the last series of appeals. And I'm sure you know that Mr. Wheeler's time has been a cost, a direct cost to the municipality. And Jennifer and I have spent hundreds of hours, and we know planning has too. So I might suggest that another recommendation might be to increase the cost of the appeal filing, which I believe is $1,080 right now. And so that might be one option, that you want to make a recommendation about increasing the cost of the appeal filing. But I also don't disagree with this recommendation.
Well, my thought on that issue is, you know, it's what you're suggesting is that it be increased, the appeal cost be increased from 1,050 to something more realistic. But at what point do you then discourage people, you know, the public? We're not talking about developers. You know, developers can somehow price this into their projects or try to get a recoupment of that money. But individuals don't have that ability. So if you suddenly say instead of $1,050 it'll be $2,000, you are really discouraging. At what point are you discouraging proper appeals by the public? That's really what I'm concerned about.
That
Mr. Deek.
Yes, Mr. Chair. I think we can take two paths on that. One is the dangerous one to figure out what that cost is, and the other is the easy one where we let the administration figure it out for us.
Oh.
So I think the way to do it is be a bit more mindful of the concern in a way that that the appeals, and I kind of see where the developers come from. They probably see some of these appeals to be frivolous,
Yes.
and in some cases they may be actually right. And in other cases, they may not be right. So there may be a process-driven way to set that cost. But we may just want to mention that the issue of cost is a real one.
Okay.
And potentially finding a better way to address it is let them work through the numbers.
Okay.
I think that's my take on it.
Okay, thank you. Ms. Pease, any further thoughts about this?
Yes, Mr.
Don't
Chair.
want to short you.
No, I share your concern that the individual with a meritorious claim might be priced out of the market if expected to cover the staffing costs through the fee.
All right, any further comments regarding general? Oh, Mr. Wheeler, are you done explaining or giving us an overview of what was intended?
Yes, sir.
You
Mr.
are.
Chair?
Ms. Jones.
Sorry. I have one other comment about a major change that I proposed to you and Mr. Wheeler last night. And I believe it's such a significant and important change, I'd like to mention it to you. In the current code, when someone files a brief, the clerk sends a notice that the brief was filed and you can come and pick it up. And you have to pay the costs or whatever. And then they come it up and it triggers the briefing schedule. And as I was looking at this last night, I realized this was written in the day when people were filing big, fat paper briefs. So they filed with the clerk's office. They weren't going to mail it to you. They probably didn't know who you were. But now we know. This is all online. It's all electronic. The briefs are filed electronically. So I'm proposing eliminating the clerk as the middle person or anyone as the middle person, and the appellant files their brief on the planning department and any interested parties, and that's defined in the code, and then the appellee files their brief on the appellant and any interested parties. So I would propose that probably eliminates all of these huge time constraints that people are concerned about. It would really expedite the process. And it's more like what we're used to in private practice. Your briefing schedule is triggered by service of the other party's brief. Or you make a hard deadline. Maybe it's, instead of 15 days, it's 20 days after the brief was filed, or because they could get an extension. So anyway, it's a major change, and I just wanted to point it out that you may, I will comment on it when we come to that section.
Okay. Anything further? Yes, Mr. Stewart.
In that same regard, what I'd like to see then is something posted on the Muni website so that the rest of the people can see what's going on, and even people that are not outside of, or that are outside of the area and they're interested parties, so that you get everybody a chance to see the same documentation. And it needs to be timely, I think, put on the Muni website.
Yeah, Mr. Chairman,
Yes,
we'll discuss
Mr.
that
Wheeler.
when we get to that.
Okay.
So yeah, let's definitely discuss
Yeah.
this one. I have
Yes,
some thoughts
I-
on that too.
Yeah.
I do too. All right. So, anything further in terms of general discussion before we get into specific paragraphs?
Mr. Chair,
Ms.
I am
Jones.
sorry, but on page 1 of the document, I'm going to tell you that I do not believe this ordinance makes sense. It starts with the A and goes to 3 with appellees before the board. I think you have to include appellants. It's just paragraph 2 of that section.
Well-
We refer to appellants throughout.
Well, if
Mr.
you
Chair,
look
Madam
at,
Clerk, the stars mean that A1
That
and
they-
A2 are not being edited.
Yeah, so it's
Correct.
just,
they're there.
Correct.
So I'm not sure what you're asking.
I just think for context, it's important for someone reading this ordinance to know who the appellants are before the Board of Adjustment, because all of a sudden you're talking about appellant shall, and you have no idea who appellant is.
Yes, we do.
Well, I will tell you, Mr. Chair, the public doesn't. They struggle very much with understanding who the appellant is.
Well, wait a minute. If you look at 2103-050A, it says item number 2, appellants before the board. Item number 3, appellees before the
Oh,
board.
I have a wrong document then.
no, it's just that, I think what's not clear is that the stars are so subtle that no one knows that section still exists. I mean, that's the whole point, right?
Sections 1 and
1 and 2
2 are
still
still there. Isn't that true, Mr. Wheeler?
Yes, so what
So
what Barbara's suggesting is that in this draft, we include 2,
Yeah.
even though it's not being edited.
Yes.
Just to help people
Oh,
when they read.
Yeah.
I see. In terms of reading. Well, what
Yeah.
about number 1?
And
Or make those stars
This is-
like big letters
this
that
is a
this is
sti-
still in the code, something like that.
this is a stylistic thing.
Yeah.
Typically, I've seen drafters not include that because
Yeah.
it makes the ordinance.
Yeah.
really
Yeah,
Right.
I mean,
long.
it makes
So,
it really cumbersome.
And Mr. Chairman, Madam Clerk,
Yes.
I did look at your edits, and I'm actually not sure that I would recommend the edits that you've made for the first few pages regarding this. I don't think they're required changes, but I was going to talk about them after we work
He-
through my draft.
Okay.
if that's
Here's
all
my
right.
suggestion of how we handle the clerk's comments. That we first go through Mr. Wheeler's suggestions, and then we turn to the clerk's comments that she sent out last night.
Okay.
Okay? And simply address it in that order. Otherwise, we're going to be totally lost here. We cannot incorporate both at the same time. Okay? So let's, having said that, any further thoughts on discussion here, process, the way to proceed right now? Nope. All right. Then let us turn to Mr. Wheeler's suggestions that he sent around at 10:30 night before last. And the version that he has, somebody gave me a red line version, and that makes it very simple to proceed. So I would simply suggest that we go to section 4A and 4A, and leave it at that.
Yeah, so I will just hit the first page real quickly. It's just stylistic changes.
Yep.
The deletion of 3B at the bottom, that's all about removing that notice of intent.
Yep.
So it's no longer a requirement. Okay.
Yes.
Now, 4A, which they proposed as an addition in that section, I am proposing we just delete that because recall that I mentioned I had a conversation with Quincy, who I believe is actually on the line if we need her, that the planning department's intention is to have a written decision on every case, regardless of whether or not there's a known appeal coming. So there is no reason to file a notice of intent to appeal because its only purpose was to trigger the creation of that written
Okay.
document.
All
But since
right.
it's going to be done anyway, we don't need that anymore in there.
Okay.
So that's all that I'm doing with 4A is get rid of that. You don't need it.
Thank you. Any discussion regarding that, Ms.
Mr. Chair, I guess I
Dees?
just need to clarify. So the red on the draft that we are reviewing.
Yes.
These are recommendations of Mr. Wheeler
Mhm.
that
Yes.
we are considering whether to endorse or adopt through our resolution. So these have not been approved by the Planning and Zoning Commission or the Planning Board.
That is correct.
These are our
So,
additions.
in front of you actually is the entire ordinance, not only their changes, because you could choose not to accept their changes if you wanted to, But my recommendation's on top of
Okay,
those.
so the red is, but
The
the
red
red
is
is
mine.
new
Yes.
Yes.
changes. Okay,
Yes.
brilliant,
Yes.
thank you.
Okay, all right. Any further discussion regarding 4A and the heading of section 4?
Just
Are we-
one clarification I want to
Okay.
ask.
Yes, Mr.
So
Deek.
findings of fact and decision. Please ensure that I know that this is for all the land use boards, all three.
That is my understanding, yes.
Okay.
I think that's fairly clear from, at least that's my reading as well.
Well, that just okay.
And you want to verify that?
Yeah.
That's the intent. Okay. Mr. Stewart, any comments?
No, I agree with that.
Okay. Anybody else? Ms. Jones? No? Mr. Wheeler?
To Mr. Deek's question, you'll see in 4B it does say findings, effect, and decision will be submitted to the board or commission. So it's intended to cover it.
Okay.
All right. Ms. Jones?
I do have some concern. Capital A on this section is appeals to the Board of Adjustment. And that section says the director shall prepare his proposed finding and submit to board or commission. And I think that is a concern throughout, that it doesn't say the land use board or commission or the lower administrative board or commission. And again, I'm telling you this because these are the questions that the clerk's
People-
office gets from the public when they're trying to find appeal.
Somewhat similar. That's my concern. That we do know that this is coming for the lower boards.
I must tell you, I view
Yeah.
this as fairly self-evident from
Okay.
the reading of this. And if the clerk gets comments about this, well, somebody needs to read the actual language.
Mr. Chair, I
Ms.
did note as we proceed down through the ordinance, there are places where there is a reference to board hearing and not board or commission hearing, so we might want to ensure consistency throughout.
Consistency is important, I agree. So what is it that you're saying? That we ought to specify the boards?
No, but
commissions
that
or-
it say board or commission.
In some instances, it only says
In-
board.
Board, yeah.
Not in this particular paragraph.
Not
No,
Not in this.
particular
Right.
paragraph.
All right,
We'll
well,
watch
let's
for it.
keep that in
Okay.
mind
Yeah.
because I think that makes sense.
Okay.
Yeah,
Okay?
me too.
Yes.
All right. Anything further regarding 4A?
No.
Seeing none, are we in agreement with the way it is written?
Yes.
All right, it appears we are. Then let's go to B, Notice of Appeal, and there are 3 little sub-paragraphs there. And that is where I believe Mr. Wheeler intends to shift the obligation of process from the clerk's office to the planning director, to the planning department, basically.
Yes.
Isn't that correct, Mr. Wheeler?
Yes, this is part
Would
of
you
that.
go quickly through the changes that you
Sure.
have in little I, double I, and triple I of B, 4B?
Yes. So for my edits, you'll see in what is now B2 that municipal clerk has changed to planning director. At the end of that, I'm suggesting that the notice of appeal form be a simple form. Right now, what we've been doing is allowing people to, or calling them out to put in their statements of issues on appeal, right? So we know in our one case, they submitted, a 40-page statement of points on appeal, and then didn't file a brief, which is sort of the opposite of what I think people intended this to be for, which is sort of give us some notice of what your issues are, and then write us a nice brief that really explains your arguments. Well, again, that's pretty cumbersome for people because they don't know how much they should put in that notice and how much, and what that means for the brief later. So my concept is just file a form that says you're appealing this case. When you do your brief, you're going to outline your arguments. Anything you don't argue is not an issue. Just keep it simple. So I think we don't need this 5-page pre-argument argument. Get rid of that.
So, and you're addressing little double I
Yes, sir.
of 4.
Yeah, I do. Well, what you're saying here is that.
Mr. Deek.
I'm sorry.
Go ahead.
I'm sorry. Thank you. I do see that you listed. Well, actually, it wasn't you. It already says in a form prescribed by the municipality, which in this case then it will be planning office form.
Yeah.
They have plenty of forms. They can add another one. There's all kinds of things to do at planning. So I think that's a very good way to address the issues. and hopefully the person who will figure out that form will maybe list your reasons or something and make it concise.
I'm not even sure you
But-
need to do that, really, but you need to identify the decision you're appealing
Mhm.
so that we know what case it is. But again, there isn't anything served. In my mind, nothing is served by trying to
Yeah,
have somebody
right.
figure out what
Okay.
other issues are there, because they tend to overdo it.
Uh-huh.
And then you've got to include that in the record.
So this is
and
just a
every
notice.
blah, blah, blah. It's
Okay.
just a notice.
Mhm. Okay, I got it.
And so what you're really saying is there is no room to put in there 40
Right.
pages of
Right.
points on appeal.
Yeah, we don't want that.
Okay.
I don't think it's
Is,
helps
is
anybody.
that clear from this? That points on appeal are really deleted? That they are not to be put on the form? Or is this something that we have to wrestle with the planning director now over? What does this form look like?
Well, we just did that.
Okay. Ms. Jones.
Jennifer is bringing a copy of the form of the appeal, and of course, the planning director could use a different form.
Yeah.
But the current form is, we just amended it last year, and the form says what you're appealing from.
Yes.
It's from the list of jurisdiction in A1. And I think you could add some things to the form, because it's the form prescribed by the municipality. The form could say you have to attach the decision, which I think is a really good idea, because I think, obviously I'm telling you my unfortunate experiences with people who don't understand this. They appeal too soon or they appeal too late. And if you require them to attach the decision, it's real easy to see the approved decision. So that would be one recommendation that I would have, at least on the form, and I don't know if it needs to be in the code, but it should also have a certificate of service on it. And the notice of appeal should be served to whoever the planning director served the notice of findings of fact, which of course we all agree
Well-
should be posted on the website. And I think you could put something in the code that says no additional materials or arguments shall be provided with the notice of appeal. I think all of those could be helpful to the board or whoever's managing these cases.
Well, I must tell you, my suggestion is that we leave this to be developed by the planning.
Yeah.
Yeah.
I agree.
And leave it at that. By the way, I'm looking at time.
Oh,
I
okay,
do
sorry.
intend
Yeah.
to go home at 11 o'clock.
Okay. I
So
think you
we
have
do
some
need
other
to-
issues. That's why I moved this meeting. That was another meeting, right?
Yeah,
Well-
Dennis and I
Yeah.
have another meeting.
So yeah.
All right.
Okay.
Are we okay then with 4B, little I, and double I? And then, Mr. Stewart, just
Okay.
very briefly, please.
Okay. I think we should use planning director as we have here in all of these. I think it'll help the public know who we're talking about. So that would mean you go back and add planning in A.
Oh.
And then, it
The
just reads.
director, the
director.
planning,
I think we need to be consistent. And
the
call
planning
it-
director in little A.
Yeah.
Instead of just director.
Yep.
Well, and I actually think you can go the other way, because I think director is called out in Title 21 to mean the planning director. So you can do either or.
How
It
about
should
this?
be
It is.
consistent. It
It
should
is,
be
but I
consistent.
I think
The-
director is
the-
used in the code
The
elsewhere.
public is going to be, I think it's easier for the public to see it again and again and again.
Yeah, I understand, but throughout Title 21, they just use director, I believe.
So
Mr. D.
Okay.
I think
Very
this,
briefly.
This is one of those issues where we can leave it up to Mr. Wheeler to find the right, consistent way to do it. I do
Okay.
agree, on the other hand, that if I'm leading as a public member of the code, should say the planning director, even though if it's defined in the code.
Yeah, so I'll deal with
So you will add to A, planning director in the first line as opposed to just director. Is that agreed?
That brings up one thing. I just want to get this on the record. With the way this is written, I think this necessitates a change in the AM.
So, Mr. Chair, board members, I would recommend we don't worry about the AM at all. That's an administration function to describe the AO, and we don't know what they're going to do with your recommendations. They'll have to
Okay.
write it differently or rewrite it or change nothing. We have no idea. So I wouldn't worry about that.
All right. Any further discussion? We have added the word planning before director in the first line of A, okay? All right. Are we then okay with little I and double I?
Perhaps if I may, Mr.
Ms.
Chair.
Peace, yes.
Well, skipping down to 3.
No, we're not there yet.
Okay, all right. Well, it affects 1, but go ahead. Down to 3.
Okay, all right.
All right.
Little triple I.
Okay, so what I'm recommending here is we get rid of the concept of a cost bond. I don't think anybody knows what a cost bond is anymore, and I'm not even sure where you get a cost bond these days. So rather than cost bond, they make a deposit. A deposit is pretty straightforward, pretty simple. Everybody understands that. And then I just clarified that, if the deposit for preparation of the record is greater than the actual cost, they get a portion back. That's pretty standard. Am I correct,
Okay,
Madam
any
Clerk?
discussion regarding that?
Sorry,
Ms. Jones?
you need to go back to I and change cost bond to deposit.
Yep. I missed one.
Thank you, Ms.
Yep.
Jones.
Cost.
That
My
was
bad.
my, Mr. Chair,
Paying
that
the
was
appeal
my
fee and cost.
deposit.
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 That was my comment,
All right.
too.
Thank you, Ms. Pease. All right. Anything further regarding this? I agree, by the way, this cost bond issue is a concept of the 1960s and 1970s. That's really what it is. All right. Any further discussion? Mr. Deek.
Mr. Wheeler, then the deposit will be then defined properly so everyone knows where to go to figure out what that is, right?
Isn't there a section that,
Yes,
that
the-
specifies this?
Yes.
Okay.
There's
I
a
think we come to
requirement
this.
to provide an estimate, I believe.
Yes.
No, that's the reason. So I want to make sure that when we say deposit, there is a way to go and look for so everyone knows what that means. Because
I
it's
think
like
it's commonly.
Well-
I think it's a common term, cash deposit. I don't think it requires any special definition.
okay,
Yeah,
as
but-
long
but-
as you're good with it.
Yeah.
But there is a
There's
section
a
there, if my
mechanism.
memory serves me correctly, that specifies the deposit, what it consists of.
Yes.
And that's Mr. Deek's objection, that it needs to say somewhere. Where is it? Where was
In
this?
It's
little I, 3 little I.
There's a later section that talks about determining what the
Yeah,
The fees
deposit
are.
amount should be.
that's
Yeah.
what I'm talking about.
Yeah, it's in here.
It's somewhere further down the road, as it were.
So in 3, it says that the deposit will be equal to the estimated cost of preparation of the record. And the estimated cost is something that the planning director has to provide to the
Oh, there it is, yes.
Okay, no, that's all. I'm
Does that
good
make
with it.
sense?
Yeah, that's
Okay.
That's
Any
all I want.
further discussion regarding triple I? Ms. Pease?
Spelling in
Oh,
the last,
please.
next to last line, reversed in whole, not reversed in while.
No, that's deleted.
No, that's
No,
part.
it's
No.
Sorry, what line?
not. Top of page 3.
all-
Page 3? Oh, you switched pages.
It's,
No,
it's
Yeah,
part
it's
of it's part of the
continuation of-
paragraph.
Previous. Here.
It's a continuation of,
No, but she's saying
3I.
she's
But
saying
that's
it's
all
on-
deleted.
She's saying page
No,
3.
the next page
Turn the
has
page over.
partial on 3.
okay?
Right here, it
The
says
word
while.
while should be
It should be
whole.
whole.
In whole. Okay, all right. You're taking over Mr. Stewart's role, Ms. Pease.
She is.
That's good.
I hope I can fill those shoes.
Okay, all right. Anything further regarding little triple I? Anything further? Are we in agreement then regarding triple I?
Yep.
Okay.
Mr. Chair, I know you want the clerk's comments later, but I am going to put a comment here. There is nothing in this about a notice of intent to file a brief. That was on page 1 and removed. And it seems to me that it has to be added back in, and it should probably be added here. But that's a separate issue.
And
Ooh,
Mr. Chair, Madam Clerk, I believe it's later in the ordinance.
Okay? I did not see that.
So we'll watch for that.
Okay.
okay, anything further? Let us then, we are in agreement regarding 4B, little I, double I, and triple I. Okay, we then come to page 4.
Mr. Chairman, if I might,
Yes.
just because we're walking through changes proposed by the admin, we should at least on each page just quickly say that this is a deletion that's proposed by the administration. Page 3, it deletes all of that stuff about the notice of intent to appeal in the 7-day period.
Okay.
That's what this is doing. So just making it clear that that's
Yeah.
all that capitalized stuff is a deletion.
Yes.
and you're
Okay,
with
all
that.
right. Dennis, you better keep track of all of this
Yes.
because you're going to be concocting the resolution that incorporates all of this.
Correct. So I just want to make
Good
sure
luck.
that we're calling out not only things that I'm
Okay.
recommending, but also what the administration's doing, so that you're okay
Okay.
with that as well.
All right.
Yeah.
Thank you. Let's go to page 4, and what used to be paragraph 6 is now paragraph 5, and it's entitled Appeal Record. And there's one change that Mr. Wheeler is suggesting.
Yes, Mr. Chairman, this is part of that shifting of responsibility to the planning department. And then part of that, also, they're trying to clarify that there was confusion over what it meant to perfect an appeal. It was a term of art, and nobody really knew what that meant. What does it mean to perfect the appeal? So change it to filing, and I want to make clear that the filing is that not
Based on
only the paperwork, but the fees and costs as well. So that's why I included 4BI through 3, so it's clear that it's all 3 of those things from 4B.
Okay.
All right, so that's all that is.
Any comments regarding that particular suggestion? Ms. Pease, anything you?
No.
Okay, Mr. Stewart, anything? You're good. Mr. Deek is good.
Actually, Mr. Chair, so we will somewhere say that there should be reference to board and commission, correct? Because 5A just says board hearing.
Yeah, again, we did.
Transcript.
At line 21.
Yes.
Well, I can add in or commission.
But this is a standing
Board.
comment for every
For
place
every-
Right.
for
where
every
we
place.
have
Yep.
that issue that
Yeah.
should
Yes.
be.
So,
Okay.
so I won't
No. It's,
point out any other
thank you for
circumstances,
pointing
but I
it
just wanna
out.
make
I
sure
Probably
that-
good if
appreciate
you
that.
do.
Okay, I'll try to.
Okay. Anything further? And Ms. Pease, you will notice that in 5A it refers to the planning director, not just the director. Okay. If we are good with 5A and B, Mr. Wheeler, 5C has a change that you are proposing.
Yes. So I thought it important that when the planning director hands off the record, it also includes any notice of intent to file a brief filed by any appellee, so that the clerk's office is aware of who the appellees are. Now, there's a further
Wait
discussion
a
about
minute.
whether this falls to the clerk's office or not, but for the moment, want to make sure that that notice of intent is passed over as well.
Well, wait a minute. We have deleted notice of intent.
Exactly, Mr. Chair.
So
yes,
that
this
needs
is
to
what-
be deleted altogether. All reference to notice of intent needs to be deleted.
No.
Because
This
when
is-
you look at 4A, it deletes it.
Mr. Chairman, different concept. So this is part of why the code's confusing. So there's a notice of intent to appeal. This is the notice of intent to file a brief. So the appellees give notice that they're going to file a brief. That way we know who to send the appellant's brief to. We know who the opposing side's going to be. So appellees file their notice of intent to file a brief so that everyone knows, oh yeah, they're going to respond to the allegations raised by the appellant. So it's a different notice.
That is confusing.
And that's been in the code. That's not a new thing.
Is it in the definitions? Both of those in the
No, they're not defined. There's a form for it, I assume. There's a form
what
for
I
it.
meant is that if
But it's deleted here, and we haven't, so now we've gone through the code.
Yeah,
We
that was
haven't-
that's your comment that
we
you raised
haven't-
earlier, so we're going to come back to that.
But we haven't seen an addition, and now you're referring to
I
it.
understand.
So my concern is, it needs to be a cookbook, and we need to go through the cookbook and do things in order,
Right.
and we've gotten out of order. But
Right,
that's
so-
okay.
Okay.
But that, because, I mean, you make a good point, and that's why I said I think it's in here, but we do need to come back to it if it's
Okay.
not. So that's,
Okay, if you would
Yep.
keep track of that.
Yep.
Okay. All right, so the notice of intent,
to file a brief.
file a brief.
Okay.
Is current code, we're retaining it. All we're really changing is that we make sure the handoff includes those notices so that
okay,
whoever has that responsibility, whether it's the clerk's office or the assembly council, they know who they need to be in touch with.
okay.
Okay.
And
So-
just 1 second, let me see that I understand this. To go on with 5C, on page 5, it talks about the municipal clerk shall serve a copy of the record on the appellant. And on the appellee who have filed a notice. I see. Okay, all right. I now understand. Okay. Any further comments, Ms. Pease? You were
Yes, Mr. Chair, it's just punctuation, but after appellant, it should be a comma, and then after file a brief, it should be a second comma.
So on the
Through the chair,
appellant.
Ms. Pease, if you could you give us the line
Oh,
number and the page number? It'd be a lot
sorry.
faster for us to keep up with you.
10.
Yeah, I'm working off of a couple different copies.
Yeah, you're talking about line 10?
Yeah.
Yep.
There should be a comma after appellant
Yeah.
instead of a period.
Yeah, and then I believe there should be a second comma after, I'm sorry, I tried to get to on the right.
Who have filed.
After the word file a brief, comma.
On line 12.
On line 12.
Yeah, okay, now I'm on the right record.
I don't know if that comma is needed on line 12. That's kind of.
So we need an English teacher
Yeah,
here
we need
to
an
figure
English
out
teacher. I
whether
wouldn't necessarily
commas are
put a comma there.
required or not.
I would just leave that the way it is.
I would too, except delete the period on line 10.
Yep.
That's what I would do.
Well then, okay.
May I go up and explain the rest of my change?
Yes,
Yes.
please.
Okay, so the 3 business days sentence on line 2, that's part of the home builder's recommendations to speed up process. But in this section, what's happening is that the planning director is going to provide the record to the clerk along with notices of intent to file. And then it calls on the clerk to serve notice on the appellants of costs. That makes no sense because I've shifted all the cost issues to the planning department. Planning department takes care of accepting the form and preparing the record and the transcript and collecting the fee. So we don't need the municipal clerk to serve notice on the appellant of the cost of the preparation of the record. That's all been taken care of by planning. And the next sentence, if the appellant fails to pay, there's a dismissal. Again, that's being taken care of, if I've done this right, by planning. So we don't need that. That all happens earlier.
Well, wait a minute. No, I'm lost. We're at line.
These are lines basically 2
2
through
through
7 on
7,
page
yeah.
5.
But you deleted all of that.
So that's
And I'm explaining why.
Oh, okay. All right. Okay.
Yeah.
All right. So my only question to Ms. Jones is 3 days. Within 3 days, is that sufficient for your office to do these things? You know, within 3 days means basically 2 days.
Well,
Can you do that?
Mr. Chair, my recommendation is that in this section, that they're asking to serve a copy of the record on the appellant. And I'm telling you, I believe that that's unnecessary and that I think this should be changed to, at line 9, it should say the planning director. The planning director has the record. Why are you transferring the record to the clerk's office and having the clerk serve the record?
So, Mr. Chair, if I may, this was the issue
Mr.
which
D.
Barbara brought up earlier, whether which you called it mediator, I think. I call it refereeing. But the point is that you don't want to referee this because you think you can. The planning director has all the tools to do this. You don't need to get involved at this point.
I agree.
That's what you
That's
said.
exactly what I meant.
Yeah.
Okay. How do we feel about that,
I'm thinking.
Mr. D?
Well, that 3 days.
Mr. Wheeler, you're supposed to think quickly on your feet.
Yeah, I actually think the municipal clerk's idea is a good one because I think she's suggesting at line 9, delete municipal clerk and put in planning director. And so it might need a little bit of cleanup, but the idea would be that once the record's done, the planning director has 3 business days to get the record out to the appellant. And that's part of the planning director's process and also getting all that stuff over to this body. So let the planning director be responsible for that distribution.
Actually, that does make sense. to
How
me.
does the municipal clerk keep tabs on what's happening so that they know what's coming? Do they get a copy too?
Yes, that's what we have
Barbara?
to. Because remember, it says on the previous page at the very bottom, upon completion of the record, the planning director shall provide the
Yeah,
record
cool.
to the clerk.
Yeah.
Yeah.
And then we're also going to tell the planning director,
Okay.
send a copy to the appellants.
Okay,
send
there's their
copies to
notice.
the,
Yeah,
or let
so
the,
there's
let
no
the appellees know
conflict
it's
there.
ready.
Okay.
Yeah,
So
yeah,
the-
I think
I
we're
think
good.
okay.
So there's one person, hopefully in the planning department, that says, "Oh, I got to do these 3 things. Get the record to this person, this person, this person. Done."
Yeah, I think that cleans it up. I
I
do
think
agree.
so. Ms. Jones?
I think there's 4, Dennis. Line 13.
Yeah, line
Okay.
13, same thing. Upon the request,
The
the planning
director.
Mhm. Shall provide a copy of the record to an appellee or the public.
Yeah, I think that makes sense.
I like that.
I like that too. Ms. Pease, any issue with that?
No.
Good. Done.
Okay, the remainder of that page is deleting new evidence or changed circumstances. As is the first half of page 6 at the top. And in the middle and down, we talk about the briefs.
Okay.
So the first change I have is changing the word may to the word shall, and this is because, again, we had that issue with someone filing a notice of appeal with all of their statements of points, argument, and then in one case we had 40 pages worth of stuff. And then because it says they may file a brief, they didn't have to file a brief.
Right.
So then we had issues with, well, now the appellee, in theory, is
Right.
filing their brief based on another brief that was never filed. Oh, gosh, what do we do? And we had a little bit of a delay, and we said, okay, we know what, they're not filing a brief, I guess. So now it's
And since-
convoluted. If they're not gonna, if they're just going to file a simple form up front, which is what we're saying we're going to ask them to do, then they have to file a brief. We have to know what their arguments are.
Okay, one,
Yes,
can I
Mr.
make a
Stewart.
comment? This brings us back to that form again. The public have to realize that form is not their brief.
Correct.
And that's what we had some of these people thinking.
Well,
They were looking at what they filed, and they didn't file anything in their brief about it, so they waived it.
it seems
So I
to
just wanna
me
make sure
that
we
if
cover
you
that.
look at the
Yeah.
appeal notice and there's no room to file 40 pages of comments, it is self-evident that you don't put anything on there.
So I think it's pretty clear that this
So-
form, or some variation of it that the planning department will need to create or adopt,
Yeah.
you would clearly indicate in here, don't attach stuff, don't include points on appeal and argument.
Yeah.
No, limit
5
them to
pages,
the-
blah, blah.
Yeah,
Just
yeah.
state it. Just tell us what you're mad about, that you're mad about this particular one case, and we'll move from there.
I
Okay.
like this. Okay.
And you
All
say
right.
that the shall. I like that you have, Mr. Chen.
Yes.
So this will clarify that you file an intent with this.
Nope. Notice
intent.
of appeal, no intent.
No intent, did
Well,
that?
Remember, we
you
deleted
filed the
intent.
notice. Sorry.
Yes.
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 And then with the shall you file the brief. That's
Yes.
why. Okay.
Yep,
So that's a process issue.
Yes.
I think it's good.
Okay,
All
now
right.
in the middle section, lines 27 through 32, we clarify if there's no brief filed, the case is over. It's going to be dismissed. Now you may change this, you probably should change this to planning director, because again, this is a preliminary process. So rather than have the clerk do that, you can have.
And you need to go back to line 26
Oh,
and change municipal clerk to planning director.
Yeah. Planning.
Yeah.
so through the chair, this was
Ms. Jones.
This was the place where I proposed making the change, and this is something that Jennifer and I, and we mentioned this to Dennis. We talked to the chair of the assembly as well as assembly counsel and his paralegal, and we recommended that the Board of Adjustment process transfer to Assembly Counsel's office. And they were agreeable to that, except to the extent that the clerk's office will schedule your meetings, staff your meetings, and take the minutes of your meetings. So we're glad to continue that service. We think we're good at that. We have struggled, as you know, with the legal parts of it. And so in this section, as you'll see later in my recommendations, I'm recommending that the record, the copy of the record, which says it'll be filed with the clerk's office, be filed with Assembly Counsel's office. And I'm suggesting that the briefs also be filed with Assembly Counsel's office. My recommendation here is if no brief is filed, that the board chair shall dismiss the appeal. And I think those are all issues you need to discuss, but I think that streamlines this. And now the planning department is done with it. They've produced the records, they're done with it.
So you think that the not, if I may,
Yeah, Mr. Deek.
So what you think is that this is the point where the notice of appeal doesn't go to the municipal clerk's office, but goes to the assembly clerk.
Oh, okay, so
Yeah.
let's make it clear. This
Ms.
is the
Jones.
brief of appellant.
Yes.
Brief of appellant goes to, I would recommend
To the-
municipal clerk or assembly counsel's office. So that's fine. I'm just letting you know where ultimately we're going here.
Yeah, so if you think about it, what we would do is back on the previous page, page 5 at the top, where the planning director is sending over the record to the municipal clerk.
Yep.
I believe
It should
the
say,
municipal clerk is recommending change that to assembly council. And then follow that up with making changes in this section, middle section of page 6, so it's assembly council is now managing these briefs, right? So it's a clean handoff from the planning department preparing the underlying record from the lower case to the briefing process, which is now the assembly council's management issue on your behalf.
so you would change on page 5, go back to
Page
the
5.
top of page 5.
Line 50.
Let's see.
9?
No, it'd be page.
Line 50.
Start with page 4 at the bottom, line 50.
Okay,
Provide the record to the assembly council.
Uh-huh.
Okay, and then
instead of municipal clerk.
correct.
And I recommend using assembly counsel's office. I think that's a little bit more neutral.
Okay.
Okay. Along with a copy of the intent to file a brief by an appellee.
And then
Okay, and then go to page 5.
in page 5, I don't think we would need any changes there. That would be we change municipal clerk to planning director for
Yes.
those items at line 9 and line 13. I think those are okay.
Yes.
Yes.
Well,
Because
what
they're
does
providing
the,
copies of the record, and
Record.
that's something that the planning department has. They're the one that created the record. They're the ones that can be responsible for providing copies of the record.
Yep.
okay, so the assembly council's office doesn't do anything
Not
Not
that
that
date yet.
They're
no.
just on alert
at this
now.
point.
Yep.
Okay. All right.
Then page 6 in the middle.
No, wait,
Yep.
wait a minute, let's go back to page 5.
Okay.
Line 13. Change that to planning director,
Yes, sir.
Yes.
as we do on line 9.
Yes.
Yep.
Okay, are we all clear on that?
Yes.
Okay, then turn to page 6.
So on page 6, line 26, change to assembly council's office, so that that's where that brief goes to their office. If no brief is filed within the required time period, municipal clerk is suggesting that she not be in charge of the dismissal, but it be you, Mr. Chair.
Okay.
You could also have the assembly council's office do it, because it really is a sort of ministerial.
It's an
thing.
administrative thing.
It's
I would
no-
suggest
so-
that it should be the council's office.
Same here.
I agree with that.
Yeah.
I think that's a good place to put it.
Ms. Pease, does
Yes.
that make sense?
Concur.
Okay, so on line 28, we change municipal clerk to assembly council's office.
May I ask a question on this one, Mr. Chair?
Yes.
And this is to Barbara. You always call that the municipal clerk. Well, you because you're the clerk, but your office is always called out as the municipal clerk. And this would be calling out the municipal council, and you think it should be the
No.
office?
No, no, no.
Assembly council.
Assembly
Sorry.
council.
Assembly council. So why the distinction?
Well, I think I want to make it clear that Dean is not Dean. The Assembly Council is not becoming a secretary. That this is a function of the office,
Okay.
and that the office performs this duty, and it may be institutionalizing the fact that he needs an assistant, so you can't cripple him without an. Anyway,
Okay.
I'm trying to be respectful.
Okay.
Okay, all
And,
right.
and you are all good with that?
Well, and
I'm
remember,
okay
the Assembly
with that.
Council is going to see this ordinance and they can make the change. They can
Yeah.
change something else.
Yeah.
So
Okay, anything further regarding
Thank you.
6A?
So
The
6A, it says municipal clerk at line 33
That needs to be
and
changed.
also at line 39.
Okay, so it's the Assembly Council's office.
Mr. Chair,
Yes?
so I am sorry, but here,
I wonder.
we have the brief of the appellant. The appellant knows who the parties are because they got the notice of intent to file a brief in an earlier section. I think you need to require the appellants to serve their brief on the appellants and the planning director, and then the clerk and no one else needs to do this. You are eliminating work for people by having the appellants do their own certificate of service.
Mr. Chairman,
Mr. Wheeler.
I do not know why it was set this way. I know this clerk mentioned earlier that there were these bulky paper records, but even so, I'm not sure why you wouldn't have the appellant take care of serving their brief on whoever it needs to be served on versus handing it off to a department to turn around and then do it. I mean, you're just building a delay by doing that handoff, and then the municipal clerk or whoever has to turn around and send it to the people that are already known.
Ms. Pease?
Mr. Chair, assuming that it's electronic, the public will also have access, I think, because the appellant can't be expected to, I don't think, serve every interested party.
Correct. The appellant would only need to serve the department and
No.
the council's office, perhaps. So the planning
Oh, but-
department had council's office and any known appellees. That's that whole conversation about making sure appellees file a notice so we know who to serve.
Okay.
Yeah.
So we should change line 33, municipal clerk to appellant, to the municipal staff assigned responsibility for the appeal.
I would just change that to the planning director and assembly council's office.
Wait a minute. Within 3 days of the appellant shall deliver. I'm looking at line 33 and 34 and 35.
Yep.
The appellant shall deliver a copy of the appellant's brief to the planning director. Is that what you're saying?
And the assembly council's office. Oh no, it's already been sorted.
No,
on
no,
assembly
no,
council's
we
office.
already have that. We
So
don't
just
need to
planning
say
director.
that.
Yeah, planning director.
Maybe
So-
you could add
So-
Assembly Council's office and the planning director at the top.
Yeah, we could do that as well.
So why in the world does the planning director need a copy of the brief? Why?
Well, there's the possibility that they can file a brief as well, right?
Yes.
So this gives them a copy of what's
Okay.
being alleged.
All right.
They can decide what they're going to do.
So
I think Barbara's suggestion is a good one. In that,
Put it on top.
Put it on top.
line what?
Line
26
26 will be changed from municipal clerk to assembly council's office
And
and
the planning
planning
director.
director.
Okay. Does that make sense?
It seems to be.
Mr. Deek?
Yeah,
Okay.
yeah, yeah,
Mr.
just that,
Stewart, Ms.
Yep.
Pease? Okay,
Just
good.
then let's
Done
deal with
deal.
line 35 then. So
Yeah.
how does that change?
So, line 35, within 3 minutes.
So I think what we're going to do there, and this is kind of messy now, but the idea would be to change that whole section.
Mhm.
So it's the appellant serving the appellees who file a notice of intent. to file
Okay,
a-
where's that?
Well, we have to rewrite.
Have to write
We have to
this.
rewrite line 33 through 40 to make that work. So,
Yep.
again, we don't have to necessarily
Yeah.
have
Do that
the
right
text
now, but-
perfect,
Yeah.
but that conceptually, if you're okay with that, we can write the language.
So then
about
it's a,
that.
that's a Dennis job.
Yeah.
That's Dennis's job.
Yeah.
Okay. I think that's fine. Any, Ms. Pease?
Just to clarify then, in this section, the appellant will file copies of her brief with appellees.
Yes.
Yeah.
Yes.
Okay. And then we still have to come back to the issue of how do we know who the appellees are?
Correct.
Well, except we know who the appellees are, don't we?
Well,
Because
Barbara thinks there's a section early on that's deleted that we need to add it back in.
Yeah.
So we'll look
Agreed.
at that.
We'll,
We know
yeah.
that's an
Okay.
issue.
I'm just
Okay.
flagging that.
All right. Little b.
Okay, little b. The appellee is filed a notice of intent to file a brief may also file with the clerk's office, and you change that to Assembly Counsel's office, right?
Yes.
A brief. That's all I'm doing, is just making it simple. We don't need to say a written response, appellee's brief to the notices of appointments and appeal, blah, 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 blah. Just say a brief.
Within 15 days
Yep.
after service of
Yeah.
notice.
And then we did change
Municipal
by the
clerk.
municipal clerk,
Yeah.
which would probably be to the appellant, right?
Yes.
After service of
Appellant.
After service of
Okay.
notice.
after service of appellant's brief.
Mhm.
Something we got to clean that up so it's clear that
Yeah.
the time is associated with the appellant following through on their service requirements. So.
Okay.
Mr. Chair?
Ms. Pease.
Yeah, as a layperson, I don't really understand or of the passing of the appellant's brief. That line is not, or of the passing of the appellant's briefing.
Deadline.
Deadline.
So what it was remember that the appellant in the earlier current version of the code, the
Mr.
appellant
Wheeler.
didn't have to file a brief, but there was a timeline to do so. So you had to let that time run even if they weren't filing a brief. So that's what this is saying, but
Yeah.
we can
Mr.
get rid
Chair.
of this because we're requiring them to file a brief. By
Yeah.
the deadline, or we don't need to get rid of it, we just need to address this more cleanly so that.
Yeah,
if-
Mr. Chair, I
If
would
they don't
like
meet the deadline, then
to.
So where are we at this point? Ms. Pease.
Well, as Mr. Wheeler just illustrated, you have to go back then and rethink what was that deadline, and so I think we're trying to avoid that kind of circular task to make this simple for the.
yeah, because think about it. We may not need that last sentence at 50 because if they don't file a brief, the appeal is dismissed.
Okay, great.
So
Perfect.
there's no reason to tell these guys they got to file a brief because they don't need to. There's no case.
Yeah.
So we got to clean that up.
Great.
Okay. All right. Are we okay with that?
Yes.
Mr. Deek, Mr.
Yes.
Stewart, Ms.
Yes,
Pease?
thank you.
I
That
am.
is busy, I like it.
Yeah.
Okay, all right.
Top
Then,
of page 7, line 2, we'll need to change municipal clerk to, I believe, Assembly Counsel's office.
Mr. Chair?
yes, Ms.
Clerk has to change.
Jones.
Well, you want to mirror the change that you made in A, and that's that the appellees
The appellee,
are serving their own briefs.
That's true. So line 2, page 7, because we've made the appellants do their service, we're going to make the appellees
appellees do the same thing.
Do the same thing. So we'll change that.
Okay. All right. Anything else regarding the top of page 7? That is lines
line
1
5, I might have
through...
to add planning, so it says planning director.
Yep. Thank you.
And then the line 9, municipal clerk, may need to be changed because it says that any brief and support there within 50 days after service of notice by the municipal clerk. I think we're not doing that, so that needs to be changed. Correct.
So we did... Tell me the change that you want.
So right now, line 5 through line 10 says the director may prepare and submit a
Yeah.
brief within so many days after service of notice by the municipal clerk. Well, that's not going to be it. It's going to
No.
be 15 days after appellant's
So the
service.
planning director may prepare and submit
Mhm.
a written response.
Yep.
Is that what you're saying?
Yeah.
A written response.
So the planning director may prepare and submit to the Assembly Counsel's
Counsel.
office a written response to the notice of appeal and any brief in support thereof within 15 days after appellant's service of the brief. Something like that. I got to figure out how to say that, but that's the idea.
Yeah.
Okay.
Mr. Chair?
Ms. Pease.
Is the, in line 5, is the correct verb may? or shall?
Yeah, they're not required. to
No,
file
they're
that.
not required to
They-
file a brief. That's optional with
Alright.
them. I think we're
He
okay
may,
there.
he may see that
Yeah.
it's correct,
It's-
everything's
it's
good.
nicely
He
covered.
may see something else
great.
where he needs
Yeah.
to file.
Yeah. We okay on that?
Yeah.
No objection?
And-
Okay.
And we'll need to make a similar change in line 15, where it says after service of notice by the municipal clerk. Again, we're not doing that, so that'll need to be cleaned up. So it's 15 days after service by
Did service-
appellant, I think, or appellee. Yeah.
Lee.
By
'Cause it's
appellee.
Yeah.
Okay. All right.
Line 18, municipal clerk shall only accept the timely filing of brief described. Do we want that to
Change
be Assembly
that
Council?
to Assembly Council.
So,
Office.
I'm gonna comment on this section here.
Ms. Jones.
I think this is really problematic that someone is saying that you can only accept briefs in this format. It's putting this burden on the clerk or assembly council's office to count the number of pages, make sure it's 8.5 by 11, and make sure that the attachments are there. That is, I think we all know what we're doing is notice filing. These are the issue of whether or not the brief is in the correct form is up to the board, or frankly, the opposing party can object to the form of the brief. But I think that putting this burden on this the administration on the clerk or assembly's council is unfounded.
Any suggestion, Mr. Deek?
I'm thinking about this because when we submit any kind of documentation, actually it's codified in some. When you, let's say, if you submit a site plan, it tells you what size, tells you what's in it, tells you, and there's checklists at the planning department. They go through it. It's codified. They have to do it, and sometimes it seems a bit onerous, and many times they make it onerous on you. But the point is that there is an actual back check of the information you provide for not particular these cases, but for actual land use processes. So I wonder if that's you found that onerous because you have to have a certain way and verifying formats and verifying the kinds. That's why you think that. To be honest, I don't know. I'm not in your position
Okay.
to know.
We need to move on here.
Mhm.
Mr. Stewart, just 1 second. Any comments regarding that?
No.
The form of the brief?
I think, no,
No meaning? Do
I don't
you
have
agree
any-
with the clerk's suggestion that that be struck as an obligation either by the Assembly Council's office or the clerk to make sure that
Well-
the brief is in proper form?
I would like to see that stay in there, but maybe not as strict as it's set out.
Okay, well, let's first discuss whether it should stay in or not. Ms. Pease?
Mr. Chair, I think it seems to me to be a technical requirement, except for the sentence on 2728, all briefs shall also include an excerpt of the record of the pages on which the brief relies. The municipal clerk might not be in the best position to know if the excerpts are in fact
Yeah.
what the brief relies on. So that I was looking to see whether this was strictly a technical exercise, but there is some sort of legal judgment in there, perhaps.
So let's first address the requirement that somebody needs to make sure that the brief is okay. The clerk is suggesting that that be left to the parties. So far, we have heard that this really should stay in there. That somebody needs to have the responsibility for making sure the brief is okay.
Agreed.
Technically. Okay, all right. Ms. Jones, very briefly, we need to move on.
The form of the briefs should start with the appellee and appellant shall file their brief in the following form. There's nothing in there that pushes that obligation to them. It is my recommendation.
Okay. Mr. Wheeler, why don't you address that very briefly?
Agreed.
I'm
Well, he is struggling. Let me
No,
tell you that I suggest. Well, this
I'm
poor
ready.
guy
I'm
is.
ready.
Okay, all
All
right.
right, I think that you should have some basic requirements, otherwise you're going to get a lot of junk.
Yeah.
I think it should go to the Assembly Council's office, and they only accept a brief if it's in the following format. If it's not, they send it back.
I agree. Any suggestion, any objection to that?
I don't have an objection to that. We just have to define what the form is. So do they do that?
Well, it says right here. If
Okay.
you look at D,
Yeah, I see it.
double I, and triple I.
Yeah.
Okay, so it says that. Any problem
No.
with that?
No. They've got timely
So-
filing is one issue, and the other is the technical.
Yeah.
I
So
would-
one's going to be the primary thing.
Okay, Ms. Pease.
I would reword this though so that it's not the municipal clerk's onus, as Ms. Jones suggested, the appellant.
You want the appellant? The suggestion is either the appellant or the Assembly Council's office.
I mean,
Oh,
then
oh,
it
no,
says
so-
Assembly
I like
Council.
the
No, the
Assembly
review
Council.
should be by the Assembly Council's office. but-
Okay, all right, agreed.
Okay.
All right, then the only other thing I have heard is that in little I, there is perhaps a desire to exclude the sentence, all briefs shall also include an excerpt of record to the pages on which the brief relies.
Mr. Chair,
Ms. Pease.
I was not suggesting eliminating that. I was just pointing out that that might require some legal review, and therefore the municipal clerk might not be able to do that, but now it's Assembly Council's office, so that's fine. Leave it.
So, I've always struggled with the concept of the excerpt of the record on
Yeah.
appeal. To me that's a antiquated concept.
I agree.
And so I would suggest that simply it's an additional document in addition to the brief, and it's called excerpt of a record on appeal. I think we delete that. It would streamline things. I don't think it serves any useful purpose, quite frankly.
I agree. And
Mr. Wheeler?
I agree, and the municipal clerk has an idea of advising the parties on how to cite to the record in the transcript. It's much better if they would just cite to the record in the transcript. Otherwise,
Yeah.
you get their brief, and you get this giant excerpt, but maybe it's only part. Obviously, it's just pieces and parts, and then you
So-
got to go back to the record or back to the transcript. I think it would be just
Okay,
better
all right.
to
So
get
the
rid of
first
that.
thing we agree on is that the sentence that reads, all briefs shall also include an excerpt of record on the pages on which the brief relies, that sentence be struck. Agreed?
Mr. Chair, should we instead say all briefs shall cite?
No.
Nope.
We
Okay.
first talk about deleting that sentence that refers to the excerpt of record.
I agree.
Okay, all right. Mr. Stewart?
That's good.
Okay, Ms. Pease?
Mr. Chair, I was just suggesting that we modify it rather than delete it so that it says all briefs shall cite the pages from the record on which the brief replies. No?
That's fine.
It should be in the next section.
Did it text a brief exclusive?
In the no.
No, in the section where you're talking about the text of the brief,
Oh,
that's where you should be talking about how to cite the record.
Okay, all right. So that
Okay,
sentence
got it.
that now starts, all briefs shall also include, that sentence, first of all, be moved to a little double I, and secondly, that excerpt of
Cite.
record be changed to
If I may, shall cite
Yes.
the pages of the record
shall
on which the brief replies.
cite the pages of the record. Okay,
Friendly amendment
yes,
and transcript.
the record and transcript on which the brief relies. And that sentence gets moved to a little double I. Is that what you're saying, Barbara?
Yeah, it would be at the end, and Mr. Chair, my amendment goes a little farther.
I have it.
Okay, go ahead, Dennis.
There's another sentence or two sentences that she suggested I think are good. I'll just read it out loud.
Okay.
References to the record and transcript shall be designated by R followed by the page number R1. References Page 1 of the record, references to the transcript of the hearing before the lower administrative body should be designated by T, followed by the page number. For example, T1 references page 1 of the transcript. And so that's just clarifying that when they're citing to the record, they use the R number or the T number that you used to see.
Okay.
I said that really fast. I'm sorry.
Yeah,
that's
we
the
got
idea,
it. But
yeah.
but you think it should be codified? It should be actually in the
I
code.
think it would helpful.
All right,
Yeah.
so we make a little 4I, or we stick that paragraph in there somewhere. Is that what you're
It could be in
saying?
this new.
This sentence
Revision
here,
of
that
two.
needs to be a separate section. That's what
Yep.
you're talking about, along with what you have.
Yep.
Does that make sense?
Yeah. So this is
Ms.
a Dennis
Pease,
job to
Does
clean
that
up.
make sense to you?
I think so, yeah.
So that we have a separate section that talks about what is attached to the briefs.
Yeah.
Yes.
Agreed.
Okay, all right. Dennis, can you figure this out?
Yes.
Okay, so it's either called double I and then everything
figure that
shifts
out.
down a
Yep.
little or something like that. Okay? All right. Any further discussion about that? No? Seeing none? Let's move to 7 down below. Dennis.
Yeah. Let's see. What did I do here?
In line 40,
Oh, okay,
municipal
yeah,
clerk
yeah.
needs to be changed.
Yep. This is about setting the hearing. So, yeah, you're right. Municipal clerk would be AC's office.
Yes. Okay.
Wherever that occurs, that makes sense. So the AC's office shall prepare and distribute to members of the Board of Adjustment the appeal packet. Is that still how, Barbara, you would
Yes.
have them do that? For the,
Okay, all right.
And then at line 42, where it says containing only the appeal record assembled by the clerk, that would need to be changed, because obviously
Changed.
that was done by planning. The Board of Adjustment shall set the date for consideration. The municipal clerk shall publish notice. I assume you're doing that still.
Absolutely.
I'm getting rid of newspaper of general circulation.
Thank
That's
you very
so
much.
expensive and doesn't.
Good.
Yep. So publish under.
Publish
would be-
notice of the
would be
date.
on the municipal website for public notices, and so that's how publish would happen. And shall serve notice on the appellant and the appellees who have submitted briefs. And there's a weird typo that was in the current code at 48, so I've changed that, so that's clean. Shall make appeal packets available to the public upon request with cost payable as provided under
Okay.
MCRs. So that's
And
what
would
is.
that be Assembly Council's office?
Yes.
Okay.
Well, I mean, is that what you want?
Yes, please.
Okay. So you're doing the notice, but the Assembly Council's office is doing any requested packets. Okay.
If I may, Mr. Chair.
Ms. Pease.
The first sentence, following the time set, that's a long lead-in, and it's confusing to me because I don't know what the time set means. It's circular. I have to go back and think about what is the time set.
The problem there is because, normally there's like 15 days for the opening brief, and then 15 days for a response, and then another 10 days for a reply. So you could calculate that, but it changes if the first brief comes in early, or if there's an extension of time and it comes in later. So we don't really know what the time is going to be, so we have to say following the time set, depends on what happens.
Okay, but as a person,
Yeah, how would you?
It's complicated because I don't know how to calculate that. You just went back and did some calculations
Yeah,
in your mind, but
yeah.
I don't know how to go back and calculate that.
No, and really this is a burden on the Assembly Council's office. So it's really not, this isn't really driving anything the public's doing. It's really driving what the Assembly Council's office is supposed to do. So I
Okay.
know
They
it's
need to
complicated,
figure
but
it
it's
out.
their problem, not really a public
Right.
problem.
Right.
But if there's a way to clarify that in this description so that the public knows how you're calculating that, that would be helpful. I don't know how to go back and do it.
Well,
Yeah,
we're-
I don't-
Or
Don't include
Mr.
it.
Deek.
I mean, you're just basically telling them that you follow procedures and the time, those times. I mean, that's supposed to be part of the deal. You could just delete it.
I don't have a specific recommendation here. Maybe you could say following completion of the briefing cycle.
Mm-hmm.
That
That
might
would be, that would,
That would be
It'd
a
be
little
Whatever
shorter
that
than
is
clear.
is up to the
Whatever
Assembly
that
Council.
is.
Yeah. Maybe let's do that. So it has some, yeah.
Following
Completion of the briefing cycle.
of briefing. Why don't you just say briefing?
Following completion of the briefing. Okay.
Yeah.
All right.
Okay, so that sentence would then read, following completion of the briefing, the Assembly Counsel's office shall prepare and distribute to the members of the board.
Yeah, I think we're replacing Assembly Counsel's office in here, except for the
Right.
notice, publishing the notice, that's still a clerk function.
Okay? Shall prepare and distribute, appeal back in any briefs. We need to leave out and any briefs filed. Or no, following completion of the briefing cycle? We already started this. Completion of the briefing. Look at line 43. And any briefs filed? Nah, we can leave it in there. It's not a big deal. Board of Adjustments.
Yeah, this is saying that what you're going to get is
Yes.
the record, transcript, and briefs.
Okay, all right.
That's all it's saying.
Okay, and then on the bottom, you are you're deleting in a newspaper of general circulation. And insert what instead?
They just shall publish notice of the date, and that's already in code.
Oh, okay,
Use
good.
municipal
Okay,
websites.
all right. Anything further regarding that section? We really need to move on here. Ms. Peace,
15
anything
minutes
further?
left.
No? Mr. Stewart?
No.
Mr. D?
No.
And I have nothing further. So we now move on to
Okay.
page 8.
So the top of 8, section 8 is just a repeat of what's already in code. The only cleanup there is the deletion of application, because that's confusing. We're talking about motion practice, and we talk about adding motion practice in later. So I think it's confusing to say you make an application for good cause, you file a motion.
So upon timely application instead of motion.
No, motion instead of application.
Motion, okay, all right.
Yeah.
Instead of motion for good cause, may relax. Okay, all right.
Everything else is current code.
Okay, all right. Any problem with that?
Why?
No.
No.
No problem. It's just that you said everything else is current code, but there's these two words deleted. Otherwise, it was current code. You just put it in red.
Yes.
Yeah. Just
Yes.
because of the way I
Yeah,
moved up
okay,
track
okay,
changes,
okay, got it.
Okay, all right.
makes it look like an addition.
9.
Because see, they didn't have this in this
Right, I got
ordinance
it.
earlier.
Okay.
That it needed fixed.
9A and
so
B.
9A, I am deleting the word meeting and changing it to hearing, because it's called the conduct of hearing. It's a hearing, not a meeting.
Yes.
And
Okay.
my strategy behind that also is to talk about what is a meeting for public participation. That's in the later recommendation. So I think it's appropriate to change it to hearing.
Okay,
That's the only change there.
all right. I'm looking at little b.
Little b
Um,
is no change. That's current code. I
Okay,
just copied the whole
here's,
thing in there.
well, I would like to change may to shall. The board shall consider only the material contained in the appeal packet.
Oh,
Yes,
okay.
agreed.
Okay.
Okay? Any problem with that?
What if it's
No.
a motion on changed circumstances or new evidence?
I would say that the first step in that process is whether or not the board agrees that there is new evidence, and if it does agree, it would incorporate that into the appeal packet. So I think
Okay.
that's covered.
Okay, all right.
So E is new, however, because there was all this debate about what is service.
Okay.
There's not a good definition of service in Title 21. There's only that
Okay.
date of service that's tied to an applicant. So this is to say that service is, if required, is both complete on the day it's sent out, and delivery and receipt of service by email shall be mandatory for all parties who have consented to service by email. So that's similar to how the court system
Yep,
does it.
yep,
So I
yep.
thought that would be appropriate. Maybe there's somebody who doesn't have email, and we have to deal with paper copies for them. But otherwise, if the parties consent to service by email, then the briefs and all that can
Right.
be handled that way.
Is there any service in there required by the AC's office?
I don't think so. No, because
No.
we've changed it all now. We've said the appellants and the appellees serve each other. And
Okay.
The Assembly Counsel's office gets a copy, and Planning Department gets a copy. But
All right, you're right.
right
Okay.
yeah.
Of course,
Last-
I have a tiny recommendation. I think you used the word, earlier it said certificate of service somewhere in the body, and I'm recommending that it be changed to proof of service and Dennis and I can
But-
fix this so that it's consistent throughout, because the public does not know what proof of service means. And then I would suggest including an example here.
Yeah.
I know that's too much, but if we want to help the public, we need to do this.
She's asking that we include an amendment that shows people what we mean by what's appropriate
Mhm.
service and certification and proof of service.
Into the code.
Yes, because remember, the appeal can be dismissed for failure to serve the notice of appeal, failure to serve the notice of intent to file a brief, failure
Yeah.
to serve a notice on a
Okay,
brief.
so that we
Agreed.
simply add a sentence in capital E that says, service is accomplished in the following manner.
Yes, and we'll add it in.
Okay.
Okay? Any disagreement with that, Ms.
No.
Peace?
No.
No, Mr.
That's
Stewart,
good.
Mr. Deek,
No.
Ms. Jones, Mr. Wheeler?
I'm
Nope,
good.
and I have nothing.
Okay. So the remainder of that page and the next few pages are part of what we've already discussed in terms of new evidence and things like that. So I don't have any suggestions there.
There is one.
I get to one on page 11.
Yes, let's turn to
Mr.
page
Chair?
11. Ms.
I
Peace.
have one on page 9.
Okay.
On line 24, item D.
Appealable decision.
It just seems to me it would be clear to the public if we put into, to establish an appeal, comma, a party of interest must file within 20 days. Because this only applies if you're wanting to apply, to file an appeal.
So as currently written, with the changes suggested, it would say, within 20 days of the approved decision, a party of interest must file an appeal.
Well,
That's basically my summation of what's in lines 24 through 33 for
Yes,
zoning,
got it.
Yes.
planning and zoning
Mhm.
commission decision.
yes.
So
I think that's pretty clear.
I,
All right, in the interest of time,
We,
this section is just about how a decision is reached. So it's kind of, you don't have to file unless you want an appeal. So I'm just going to put that in the very beginning of the paragraph, but that's all right. In the interest of time, we can skip it.
well, okay. Let us go then to page 11. You are deleting the whole section on the decision.
So this is in the Code of Regulations, and I think they just missed this, so I'm deleting it. Because remember, the idea was to get rid of that notice of intent to appeal concept.
Right.
So I think this is just something they missed, so my cleanup is to delete that. That's all. They've deleted it elsewhere, I just think they may have missed this one.
Okay. Any
so the
discussion?
whole B is gone.
deleted.
And then, just delete the whole thing.
Yeah.
Yes. Are we okay with that?
Yeah.
Ms.
Yes.
Peace, Mr. Stewart, Mr. Deek? Okay.
And so the next few
Yeah.
pages are deleting the same thing from each board or commission's regulations.
Okay.
And that runs us all the way out of the ordinance, except for additional suggestions the clerk has and my additional recommendations starting on page 7.
Okay.
There are a couple of changes on page 12.
Page 12.
They refer to the secretary, and this is still on the
The plan
Can
is
you
there.
refer to the line? Mr.
Planning.
Stewart?
Line 1.
and 8.
Oh,
So who
That should-
prepares the proposed findings?
That's the planning department.
Planning director.
secretary.
Planning,
Oh,
okay.
oh, okay.
And then it's the board on 8. Commission, or needs to be crossed out, boarded.
Commission and board, or board.
No, it's just board. Cross
It
out
is
commission.
Oh, so hold on.
Well, hold on, hold on.
Let's
The
make
part-
sure
decision. Let's go back to 21 on page 11.
this is the plating board's regulations. So these are all particular to the plating board.
Right.
So
Why do we monkey with it?
They're not a commission.
that's current code. I wonder if that is an error in current code. See, so it says, talking about planning board review at line 5,
Yes.
shall have priority over their items
Oh.
and shall become final appealable decision of that board.
Yeah,
So
of
I think
that
Bob's
board.
right. I don't think Commission's the right word. I think that
111,
might need to be board.
So it should say board instead of commission.
Correct, I believe so.
Well, it says planning board, so.
Yeah,
Well, he's good at this, isn't he?
yeah.
But
Well, he's always been like this. Okay, all right.
but
I
then,
think that was a compliment.
But then
It was a huge compliment, actually.
It's also current code that the current code then lists secretary. So do we want to monkey with that?
Well,
Who that secretary
It's a
is?
suggestion.
Okay.
They can choose to adopt it or not. We think it should be consistent, right?
Mhm.
That's what you're
Right.
saying, but they
So
can.
it should be planning director.
Mr. Chair, if I may, I
Ms.
just
Peace,
want to make sure that in addition to these motions, we still have those other two issues, which
Well-
is notice of appellees and the issue of new evidence, changed circumstances, how you get a rehearing. I'm just putting those in the parking lot.
Yes. Yep. I think
No.
I think we're at the parking lot.
Current code has board. Current code has board in there rather than commission.
Really?
Yes.
Oh,
So I wonder. Well, because usually you're supposed to cut and paste this stuff over so you don't make this mistake. So
Final, becomes a final appealable decision of the board in
Interesting.
here.
Okay.
They just
Okay.
copied it.
Yeah.
something happened.
All right, so we are now done with our changes. There are two items that are remaining. One of them is Dennis's suggestion regarding motions. And we will address that first. The second one concerns anything left from Barbara that she wishes to attend to.
Same thing here.
So,
It's possible that they copied from old code, maybe.
It's
Is that
possible
new
that they
code?
copied.
all right,
I don't know.
let's
Let's
get
look it
back.
up.
Let's get back to the matters at hand. Mr. Wheeler, you have made a suggestion, and I need to reach down here. All the paperwork that I have, that there are additional suggestions,
Yes, sir.
and that concerns motion practice.
Yeah,
And
a
it's
couple of
several
different items. The
pages.
motion yes. So the motion practice issue is because there currently isn't anything in the code that helps you figure out what to do with motions, what are the rules around motions, timelines, pages, anything that you can think of. So what I did here was I basically took the Alaska appellate rule regarding motions that they use when they're dealing with motions filed in an appeal, and tried to tweak it so it fit our particular circumstances as best I could, including trying to define what kind of motions could be handled by, for example, the chair because of routine versus ones that are more complicated or maybe substantive that should perhaps go to the full panel.
Okay.
So I know it's long, but that's
Uh,
basically the intent.
Well, okay, and I think that's good, but there are some practical problems here. Line 41 on page 1, motions determined by the municipal clerk. That's no longer done by the municipal clerk, right? That's done by the council, assembly council's office, right? Isn't that true?
If that's what you would like,
Yeah.
certainly.
Because why suddenly involve the clerk in this?
Right. Yes. I didn't know she was going to leave me all alone. when I wrote
excuse me,
this.
which line?
Line 41,
Page 79.
Okay.
page 1.
So, Mr.
Bottom of page 17, lines 41 through 50.
Okay, Mr. Deek.
So when you say add the following, Mr. Wheeler.
Yes,
So
sir.
where would we add the following?
Now, that is a next discussion we need to have. So let's just first go
Sorry.
through, before we talk about placing it, let's go through this thing to make sure that we are in agreement. All right, so line 41, we change municipal clerk, and wherever it talks in this
To,
about clerk or municipal clerk, it should say Assembly
Assembly
Council's office.
got it.
All right? And that goes for all the pages.
Yes, that'll get you to the bottom of page 18, line 42, where it ends.
Okay. Any objection to the handling of motions that is described here? Ms. Pease?
No, are we to, no, Mr. Chair, are we to the Roman numeral 2 yet?
We
Not yet.
are not yet. Not yet. Okay, Mr.
No
Stewart.
objection.
Mr. Deek?
Just one question. So, Barbara, you have obviously read through this thing.
I have, Dennis and I have discussed it. I have not read through it exactly, but it looks great.
Okay, good.
Okay, yeah, I'm good with that.
All right. Now then, if we're good on Roman numeral 1, let's go to numeral 2.
So
bottom of page 18.
for 2, I don't have any particular text suggestion. What I'm suggesting here is a recommendation. The recommendation is basically, to the extent allowed by law, allow this board to handle certain matters without having to do it in a public meeting. We're talking about routine motions or deliberations on a motion where if you're required to hold a meeting at which nobody can testify and nobody can offer evidence, why
Yeah.
bollocks things up that require you, 30 days out to try to get a schedule that meets all of your schedules when you can deal with a thing routinely in a matter of days
Okay.
or a matter of hours.
Ms. Pease.
Your explanation that no one's allowed to testify, so why have a public meeting makes sense. However, sentence on 46 and 47, it just seems to be explanatory and it wouldn't really belong in code.
Oh, no, that's what I meant to say, is that I have no code change here. This is just laying out my reasoning, my argument as to why
Okay.
I think a recommendation. Now, you may not be able to do it, right? They may come back, and this is obviously an issue that's on appeal right now, I believe, is to the extent that you can handle these matters. So,
Okay. Mr. D.
the
State Law Public Meetings Act, I believe that's pretty strict on prohibiting your ways of conducting business as a board.
turn your document around, the last sentence is a quote right out of the state statute. A governmental body performing a judicial or quasi-judicial function when holding a meeting solely to make a decision in the adjudicatory proceeding, that's exempt from the open meetings law. Great. So the idea would be, can that be translated to this board at this level?
Yeah.
And there's some problems with that because there may be some problems with current municipal charter and current municipal code, but if it can be done, it should be done.
Yeah,
Okay.
okay. I mean, that's the only concern I had, but since you already have looked at it, I could see why that would work.
Okay. Now, the next issue is, if we are okay with this, with the motion as described by Dennis here, where do we put it? Dennis, do you have a suggestion?
I don't, because I wasn't sure if you would like it at all. I think what we would do is that would be left to the people that are going to deal with any revisions to the AO. They'll put it in where they think it's appropriately located.
Well, why don't we make a suggestion?
Okay. I would say, and I got to print out the entire code here so I can figure out where to put it. We've got.
So we have a section on written arguments,
Yeah.
we have a section on appeal packet, procedural changes, conduct of hearing, scope of review, decision, remand, all of those things.
So motions can come early in the process, or they can come later in the process. Probably somewhere before you talk about conduct of
Just-
hearing, or
before decision.
correct.
So why don't we simply, no, it should be before we get to scope of review, really. Conduct of hearing, procedural changes. All right, follow number 9 and make
Okay.
this a number 10 in AS 2103-050.
So it'll fall in between 9 procedural changes and 10 conduct of hearing, which actually
Yes.
might have different numbers by the time we're all done.
Yes, yes,
But
yes.
That's the idea.
Does that make sense? Do we have a agreement on that?
No, that's okay.
Okay. All right, we are all in agreement on that. So we now have addressed this, so let's very quickly, and we have,
It'll go right in here.
I would entertain a motion that we approve the changes that we have discussed and that we direct Dennis Wheeler to prepare a final version of this and resubmit it to us. How's that? Madam Clerk?
Mr. Chair, I think upon our final review, the section on an appellee filing a notice of intent to brief is missing, and I would recommend that you add that.
Agree.
So, Mr. Chairman, if you look at page 1 of the ordinance, line 35 through 40.
Yeah.
That section is currently proposed to be deleted, but it may be that we need to add that back in, so that it's, because we're expecting appellees to file these notices.
Okay, except it shouldn't say to file a brief with the municipal clerk's office, it should say AC's office,
Well,
right?
Mr. Chair, I am making a recommendation in the draft that I sent to you and Dennis last night that you make a section, it would be on page 4, and it would follow notice of appeal, which is number B, and I would suggest a new section that is called C, notice of intent to file a brief. And
Madam Clerk, I don't know if our page numbers are lined up with yours.
I see. Okay.
Page 2, I believe, is notice of appeal in our draft.
Yes, it is. Page 2
Yeah.
is notice of appeal. And
Yes.
I am suggesting at the top of page 3, after notice of appeal B-I-I-I, little I,
Uh-huh.
right? That you add a new section C called notice of intent to file a brief.
Got it.
Okay.
So
And then that would mirror the notice of appeal, and it would have an I and a little I probably, so that it mirrors this little cookbook that Dennis set up here.
I think that works.
I think that works.
And Dennis can handle this too.
Yes.
Get to the final. So that's part of your motion for this.
Part of my motion is, and I will simply make the motion that we approve the changes that we have discussed here, and that we are directing our counsel to prepare a final version and submit it to us for quick approval. First of all,
Second.
seconded by Mr. Deek. I think we need to finalize the process. We do need to, however, schedule another getting together. Or how are we going to handle this, Dennis? Help us out, please. Do we have to have another meeting to approve this, your final version that you're going to concoct?
Through the chair and Mr. Wheeler, I think that the board can meet virtually to discuss a non-adjudicatory matter. I think that is already in code, that boards and commissions can meet virtually. So if you would like to meet again for final approval, I think we could set that up.
Okay, and it would not require public hearing and all that kind of stuff.
On your
Well,
day,
it
right?
would require, I believe it would require public notice.
Okay.
And I do, just like this one, it does require
Okay,
audience
so it does.
participation.
Okay,
Yes,
all
it
right.
does.
Mr. Deek, any comment on that?
No, I would just look at the calendar to make sure that we make it before our
Well,
appeal date.
that's okay. Before an appeal date?
Kill.
Before we
Oh,
go
okay,
out
all right.
of existence.
Expiration.
We have a, when are you dying? The
I
two
think
of you?
15.
Next week.
Okay, you're dying on the 15th, so it has to be the end of, the 14th is the very last day, which is...
I think the 15th is still good, but
No, let's
It's
make it...
October 15th. I think it's
14th.
Is it the 14th?
Okay, all right, so what day is the 14th?
Monday.
Monday.
Valentine's
No, the next week, Tuesday is the 15th.
So Monday is the 14th.
Monday's
Yes.
the 14th.
So we need to do it on Monday.
Looks like
Are you okay on Monday, Mr. Deek?
anything
Mr. Stewart?
Yes,
11 p.m.
Miss Pease?
I'll have to be.
Okay.
11 p.m.
Dennis,
I'm trying. Hold on.
can you get all this
I have
stuff
two
done?
calendars to look at. Yes, the only thing that might be an issue, but I think the clerk can let me out of it, would be the core team election meeting on Monday.
You're excused.
All right.
Okay, so 2:14, and Barbara, are we okay? Are those two still okay on the 14th?
Yeah.
Let's go forward and
And just let somebody else wrestle with it if not. Okay, what's a good time? 10 a.m.? 9 a.m.?
Earlier, if we can do it in an hour, then 9 to 10
This better be done in much shorter time.
or 11. I have a meeting at 10.
Okay,
Although-
let's do it 9 o'clock.
Okay. Are you guys good with that?
9 a.m. Anchorage
good.
time, because I will be in Seattle.
Yes.
Mr. Chair, can you clarify, are you wanting this to be a virtual meeting or in?
Yes,
Virtual.
a virtual meeting,
Sounds good. Meaning Zoom or Zoom, whatever, Teams, right?
whatever this system is called here.
Sounds good.
Okay, very good. And then Dennis, you need to get this to us
Yes, sir.
before the weekend.
Yes.
So you're going to be burning the midnight oil on
I
this
will.
thing. That's okay. You get paid for it.
That's
Truthfully,
right.
I have no social life, so it's fine.
That's good. No need for
What
that.
happens when you're not?
Okay, all right. All in favor of the motion?
Aye.
Aye.
Approved unanimously. Anything further before we adjourn? Yes, Mr. Wheeler?
Yes, in deference to the municipal clerk, I know she has maybe a couple more edits to touch on, but also, in one of them, well, we talked about empowering the Assembly Council to do case management in Title II. So just real quickly on that one, currently the Assembly Council is charged with providing you with legal advice. The clerk suggested also adding case management to AMC 22065, so it's clear that the Assembly Council is also empowered to do this new stuff we're asking the Council's office to do, which is to help you through the process of getting through the hearing. So if you recommend that, we have appropriate text that we'll come up with for that.
So moved.
Second.
Moved and seconded to include that.
Yep.
All right. Any discussion, Mr. Deek?
Nope, I like to see it too.
No
Mr.
discussion.
Stern? Okay. Ms. Pease? Nothing? I have nothing further.
And
Sorry, I'm still, if Mr. Wheeler would address whether we have found a way to ensure that rehearings can be properly requested for new evidence or changed circumstances. I'm still unclear if we have obliterated that.
my intention was to add it as a recommendation of this body that issue be addressed clearly in the code, and we'll leave it to the powers that be to come up with appropriate language if they deem that's legally required. So
Okay.
that this
Does that
board
make
knows
sense?
if it's doing it or not.
That's acceptable, just so we don't forget about it. Thank you.
Okay.
Yes, so we make sure that it's there.
I'm glad you're holding our feet to the fire. Okay. Anything further before we adjourn, Madam Clerk?
Mr. Chair, I had some minor definitions. If you would authorize me to work with Mr. Wheeler, if he thinks the definitions are important to include, we'll include them. If not, we will not include them.
And it is simply a suggestion because we're going to be discussing the final wording in any event. So I think that it's fine if you do that. Is that agreeable?
Agreed.
Yes.
Okay, very good. Well, thank you so much. I'm sorry to hurry you along, but I know there are other meetings scheduled, and
Yes.
so anyway, we will see each other on Monday remotely
Sounds
and
good.
finalize this. And the meeting is adjourned.
Good.